You're all well trained to be quiet in the courtroom. Somebody stands up. Ready? Okay. Welcome, everyone, to our panel on labor law and the Western ports. We are very thrilled as the Ninth Judicial Circuit Historical Society to be hosting such an interesting program tonight. My name is Johanna Hartwig, and I am the Executive Director of the Historical Society. I'm going to take just a second or two to tell you about the Historical Society. We are a society that does three things. We put on interesting programs like this across the circuit that illuminate the fascinating legal history of our circuit. We have a journal called Western Legal History that comes out once or twice a year and tackles really intriguing themes. Last year, our journal tackled the history of gambling law in the Ninth Circuit and the development of gambling law. Fascinating. We did a huge issue on water law the year before. And our issue that is about to come out is about the centenary of several important Supreme Court cases having to do with unenumerated rights in the public education context, including two that came out of the Ninth Circuit. So keep your eyes open for those. The third thing that we do is we have oral histories of judges and prominent attorneys. So I invite you to check out all of those things at njchs.org. The mission of our organization is, again, to enlighten folks about the very interesting legal history of the Ninth Circuit. And the second part of our mission is to amplify the importance of an independent judiciary to a well-functioning American society. I am very pleased to say that our event tonight is being co-sponsored by the Northern District of California's Federal Bar Association and the Northern District Historical Society. We are so pleased to be able to put this on together. And of course, a big thank you to the Ninth Circuit Court of Appeals for welcoming us here into the very beautiful Browning Courthouse. We're here in courtroom 3. For everyone who is out there in our virtual land, you can maybe just see a little bit of this beautiful courtroom. Maybe we'll send you pictures later. But everyone who is here in person, I'm sure that you are enjoying being in this beautiful space. So just to give you a preview of what's going to happen tonight, we are going to have our excellent panel speak for probably about an hour. And then we will leave about 15 or 20 minutes for questions from the live audience. We don't have the capacity to have questions from the virtual audience, so we'll be sticking to the live audience. And you can ask those, you will be asking those questions out loud. So just be thinking of questions as the panel goes along. And then after we wrap up the panel around 7 o'clock, we invite all of you to the very beautiful Great Hall that is just down the hallway here and to the left for a reception with delicious food catered by local legends La Mediterranee. So for those of you who are wanting CLE from this program, if you are participating virtually, my colleague will be putting into the chat a link that you can fill out the form for CLE and also a code you need to put in that form. But don't worry if you missed that, because tomorrow we will send anybody in person or virtual who registered for CLE a link to the form that you need to fill out. So you don't need to worry about doing that today. Okay. Now, let's get to the heart of this. It is my great pleasure to introduce our moderator, who will then introduce our esteemed panelists. So I am introducing someone who really doesn't need much of an introduction, so I am going to keep it very brief. Today, our moderator is Judge Marcia Berzon of the Ninth Circuit Court of Appeals. I am very proud to say that Judge Berzon is a longtime board member of the Ninth Judicial Circuit Historical Society, and we so appreciate her service to the society. She joined the Ninth Circuit Court of Appeals in 2000. And before that, as I believe many of you know, Judge Berzon had an illustrious career as an appellate and Supreme Court advocate at the firm that was then called Altshuler, Berzon, Nussbaum, Berzon, and Rubin. She represented many unions throughout her career, as well as other interesting clients. So she has a lot of, I think, personal knowledge that's going to come into this today, as well as an interest. Judge Berzon is a graduate of Radcliffe College and of Berkeley Law. And following law school, she clerked for Judge Browning of the Ninth Circuit Court of Appeals, for whom this beautiful building is named, and for Justice Brennan. So please let's give a warm welcome to our moderator, Judge Berzon, who will introduce our panelists.
Hello. So you probably all recall seeing container ships stacked up in the San Francisco Bay in recent years on both sides of the Bay Bridge, including on weekends for a lack of capacity at the Oakland port to unload the ships and send the goods in the containers on their way by railroad and truck. There is shipping from the Oakland port to Asia, the East Coast, between West Coast ports. The shipping is of consumer goods, electronics, agricultural and industrial products. What the impact of the tariffs is going to be on ports, we don't know. Yeah, no, the reason I'm babbling a little is because I'm getting a cold in my ears. And so it's a little hard to talk over the ring that I hope the rest of you cannot hear, which I'm not answering. So today we're going to hear about the people who sail those ships, build them, load them, and tow them into harbor. The maritime history of California dates to the 16th century. In the 18th century, for example, trade from the East Coast could take 200 days around Cape Horn. And then there was the gold rush, which began the port of San Francisco. At that time, by steamer and land over Panama, you can get here in 40 days. The port of San Francisco was a key to the city's growth. There were 793 ships in 1849. Now, because of the containerization, San Francisco is not in the top 50 ports in volume in this country, and the largest ports on the West Coast are Long Beach, Los Angeles, Seattle, Richmond, so said Wikipedia, which surprised me, Portland, and Oakland. So who does the work that builds the ships, runs the ships, loads the ships, tows the ships into port? That workforce has a fascinating history, which we will hear about today. The history is critical not only to Union history of the West, but to its civil rights history, to the development of containerization, and to all the changes in the maritime trade in recent years. So first, we're going to hear from Don Marcus, who is the president emeritus of the Masters, Mates, and Pilots, AFL-CIO. Captain Don Marcus is a professional mariner who served as the president of the International Organization of Masters, Mates, and Pilots, AFL-CIO, from 2013 till 2024. During his seagoing career, he sailed in all licensed deck officer capacities, from third mate to master, aboard U.S. flag ships engaged in international trade. He was commissioned in the U.S. Naval Reserve. He received his honorable discharge in 1986. His last shipboard assignment was as master of MV Sealand Pacer. He is an advocate for the American Merchant Marine and for America's working families. He's been a union member throughout his working life. He graduated from the U.S. Merchant Marine Academy in Kings Point, New York in 1979 and joined the Masters, Mates, and Pilots when he graduated. He was elected president of the Maritime Labor Alliance, a 6-union partnership, in 2013. And the alliance was over in 2024. And he told us today that he just returned from a meeting in Geneva of an International Labor Organization meeting devoted to international maritime trading. But not only that, Captain Marcus is a law graduate as well. He graduated from then Hastings Law School in 1990. Originally from San Francisco, he lives in Baltimore. So he is going to give us some history of how we got to where we are today, both as to the ports in general and as to um, its labor relations in particular. Okay, thank you, Todd.
Thank you. Thank you, Judge Berzon. Thank you to the Historical Society, Johanna. It's much appreciated. It's a pleasure to be here. It's always great to get back to my hometown, the once great port of San Francisco, and it's still a great place. Still a great place for many, many reasons. But for myself, it's been a privilege to work in the maritime industry for a better part of 45 years. And to start here in San Francisco, to ship out of San Francisco. And what gave me an appreciation for labor history was working aboard ship. When I started in the mid-1970s, there were still old-timers aboard the ships who were in their 60s, who had been through the labor wars of the 1930s, World War II veterans, and shipping in the 70s was a whole nother world, far removed from ships of today. And the lifestyle was far removed. And it was a wonderful experience sailing in the U.S. Merchant Marine and working with a diverse group of seafarers, really from all walks of life in the United States. Also, for myself, a defining moment in my career as a union member was a failed strike, a tanker strike in 1984, where our particular union called an ill-advised strike. We were undermined by a competitive union that was successfully took some of those jobs, and we lost a third of our jobs for a union. And for me, as a rank and file member who knew nothing about labor law, I learned quickly that it's not good to be deemed a supervisor, and it's not good to be standing there with a picket sign and watching other union busloads of mariners drive through your pickets. So, and then the aftermath and the hardship that it created for so many of our members made a deep and abiding impression. And what's fascinating about the industry, particularly here in San Francisco on the West Coast, is the competing interests and different variety of experience from the 1930s. I mean, the big strike, 1934 here in San Francisco, the general strike was a strike up and down the West Coast. All the maritime unions were involved. The Teamsters were involved, which were a critical component of the success of that strike. But the players involved were the International Longshoremen's Association, Pacific Coast District, which consisted of longshoremen and locals up and down the West Coast. That in 1938 morphed into what became the International Longshore and Warehouse Union, led by the famous and great leader Harry Bridges, who I'll talk about a little more. And the other major union, which was one of the great powers on the West Coast, was a Sailors Union of the Pacific, led initially for many years by Andrew Furuseth, who's also known as the Abraham Lincoln of the sea that freed the seamen from indentured servitude. And he was a zealous, austere Norwegian. You can see a bust of him outside the Sailors Union of the Pacific building on First Street and Harrison Street. It's a beautiful building. Anyone can walk in the door and see this beautiful hiring hall that is still in use. And in the height of the 30s, during the labor wars, it was the leader was a fellow by the name of Harry Lundberg. And Harry Lundberg and Harry Bridges were the two polar leaders that started out together and ultimately polarized unions on the West Coast with very sad results. But in the glory days of 1934, 1935, really through 1938, they built something along with the other unions, which we are still, and for the working people, benefiting from to this day. The other unions in maritime seagoing side, there's what's called licensed officers who are Coast Guard licensed, and there's unlicensed personnel, the crew members. And the Sailors Union of the Pacific was, of course, represented the sailors. The Marine firemen, oilers, water tenders, and wipers represented the unlicensed gang working in the engine room. The Marine cooks and stewards was a famous union that developed most strongly in the 30s. It was the most diverse union of any on the West Coast, a fully integrated union, which was unheard of in its day, almost unheard of in its day. Then there was Masters, Mates, and Pilots, which was the union I'm a member of, a proud member of. And we started in 1887 in New York Harbor. Our first local out here on the West Coast was 1889. And then the oldest union was the Marine Engineers, still is, the Marine Engineers Beneficial Association, which was founded in 1875 in Cleveland, Ohio. And all of these unions and one other, the American Radio American Radio Telegraphist Association was started in the 30s. It morphed into what became later the American Radio Association. And these unions are all still in existence, and there have been other unions that grew out of them from the turmoil of the 1930s. The most famous of the unions that grew out of the turmoil of the 1930s was probably the National Maritime Union, which was a left-wing union. It was closely allied with the International Longshore and Warehouse Union, which were both became CIO unions and were both socially very progressive, believed in equality, believed in social equity that the old school AFL unions were very late in embracing. And the strike in 34 was precipitated by the longshoremen, and then the seamen walked out almost at the same time, and then the officers' unions walked out shortly thereafter. And I'm proud to say, as an MMP member, that in fact, I read the minutes of our strike meeting from May 19th, 1934 at the ILWU convention this last summer. And it's proud to be a part of this heritage. And it's something that our members and most maritime members are very proud of, to have this heritage. Other key unions, of course, were the other metal trades, the shipyard workers, scalers, and the as I mentioned earlier, the Teamsters. But the unity in a very brief period of time, fostered by a common struggle against employer, against the regressive laws that stayed in place until the Wagner Act brought a unity and a determination that prevailed in the 34 strike, which took really 2 or 3 years to fully develop the benefits of that strike. For the longshoremen, for the sailors union, it resulted in a union-run hiring hall, union recognition, and collective bargaining. And this all took bloodshed and endurance from everybody involved. At the heyday of the unity on the West Coast, a federation was created, the Maritime Federation of the Pacific Coast. The first president of that organization was Harry Lundberg, who was president of the Sailors Union of the Pacific. He worked closely with all the other unions, and there was a period of great progress, both in collective bargaining, in union recognition, and in improving the working conditions of mariners. And there was a force in the West Coast shipping industry as Judge Berzon mentioned, San Francisco was the heart of it. The West was really developed by seaborne trade. At that time, it was not only seaborne trade from overseas, it was, of course, coastwise trade up and down the West Coast, were steam schooners carrying lumber and products. There were intercoastal shipping transiting the Panama Canal, vast numbers of U.S. flag ships, both in international trade, coastwise shipping, and intercoastal transport. And the longshoremen and the seafarers together really had tremendous amount of power if they could act in unison. And they were able to exert that power in 34. And really until the mid 50s, actually mid 60s, they still had that kind of clout. Over the years, what you see now is the seafarers have lost that clout, that economic clout. The longshoremen still have it. And for those of you who recall on the East Coast, there was a brief strike at the International Longshoremen's Association, and President Biden refused to invoke the cooling off period. Then when President Trump came in, he supported the ILA. So the ILA, which threatened a coastwise shutdown on the Atlantic and Gulf Coast, prevailed in a very important strike over the issue of automation. And for those who remember, in 2002, there was an 11-day lockout of the ILWU. Again, one of the main issues being automation. But the seagoing side of things, because of the decline of the United States flag shipping, the coastwise and intercoastal trade disappeared after the Second World War, replaced by railroads and trucking. And on the international trade, where it used to be 60% of U.S. foreign trade was carried aboard U.S. flagships, today about 1.5% of U.S. foreign trade is carried aboard U.S. ships. So seafarers are grossly declined in number under the U.S. flag. We were outsourced after the Second World War, really the first industry to be globalized by the flag of convenience system. If you see ships today out in the bay or anywhere else, the odds are it's got a Liberian or a Panamanian or a Marshall Islands flag on the stern. And the seafarers are usually the lowest cost seafarers that could be found. And there's exploitation of seafarers, and even good companies that have Marshall Islands flags or Liberian flags, they avoid taxation. They avoid strict enforcement of regulatory standards, and they're really outsourcing labor for the profits, obviously, of U.S. beneficially owned companies. I think the importance of that is for the U.S. commerce. We are really dependent on foreign flag companies, foreign flag mariners. The history of the U.S. merchant marine is one of no cost is too great in time of war to provide for the merchant marine, but no cost is too small in times of peace. So the merchant marine generally declines in times of peace. Then as war clouds appear, there's a vast investment in shipping. This happened in 1916 when a shipping act was developed. It happened in 1936 before the Second World War when another merchant marine act was developed in Congress. And today, after 40, 50 years of decline, once again, with fear of China, there is some stirring in Congress and recognition that the U.S. merchant marine and the seafaring labor pool is woefully deficient. But all that leads to the fact that the seafarers are really, other than transport to Hawaii and Alaska, they're almost negligible economic impact. But the longshoremen still have tremendous economic impact. As you all know from experiencing COVID, and the ships that Judge Berzon mentioned were stacked up in LA, Long Beach. It's stacked up in San Francisco Bay and Puget Sound. And the power of the longshoremen remains intact. And that's testament really to the great leadership of Harry Bridges, who in the 30s built the ILWU, split off from the International Longshoremen's Association, and created an enduring institution that controls cargo and loading and discharging on the West Coast, and as socially progressive unions. One of the first unions on the West Coast that welcomed African Americans. At one point in the history of the ILWU, Harry Bridges got up in front of his membership and said, if we're down to the last two longshoremen on this coast, one of them is going to be black. And he was steadfast. He was left-wing. He got a lot of criticism. He was threatened with deportation, no doubt in this courtroom, 4 times in his career. If he had been around today, he'd probably be in a jail in El Salvador. But in any case, he was a great leader. And for the maritime industry, he was a catalyst that put it together. And from about 1938 until certainly the 50s, the industry was very, very strong. Of course, the Taft-Hartley Act was the death knell for many of labor organizations, and it pretty much killed off growth potential for licensed officers' unions who were considered supervisors under the Taft-Hartley provisions. Of course, the secondary boycott limited what could happen in labor disputes, and the hiring hall was immediately put under stress. Harry Lundberg of the SUP was able to negotiate what they called the Lundberg formula to keep the hiring halls intact despite the prohibition of closed shops in the Taft-Hartley Act. And but the fact is that the clout of unions, particularly the seagoing unions, for legal reasons and for reasons of the economy, just lost their authority. Here is a slide showing the split that developed in the late 30s between the AFL unions and the CIO unions. The AFL being more conservative unions, of which MMP was certainly one of the most conservative. The ILWU, the National Maritime Union, were left-wing unions. The Marine Firemen, Oilers, and Water Tenders, that's actually an error. They were an independent union. They weren't in the CIO. The Marine Cooks and Stewards was a far-left union, and they lined up against each other. And sadly, they started creating competing unions, raiding each other's jurisdiction. And at times, there was more acrimony against other unions than against employers. Which, of course, is a gift to the employers, disunity among labor. But the story of the unions is an intriguing one. The Taft-Hartley Act and the supervisor exclusions put a major hurt on masters, mates, and pilots, the Marine Engineers Beneficial Association, because we could no longer organize from the bottom up. Competing unions could come in, yellow unions with pre-hire agreements and undercut. So it's been a fight for survival. And it's hard to believe. You would look at this list of unions, 8 or 10 unions still out there. You'd think by this time logic would prevail and there would be unity and we could get back to the ideas of Harry Bridges and Harry Lundberg of the Maritime Federation of the Pacific Coast. But we're not there. We struggle to survive, and we all need good lawyers. And I could tell you the masters, mates, and pilots would not have survived without a great legal team. And I'm going to give my hat off to Gabriel Terrassa and his partner, Jennifer Stair, and Terrassa and Stair, and Lisa Dominovich, who's a brilliant attorney with Altschulter and Berzon, who has helped us many times, as well as Carolyn Fisk, who wrote an important amicus brief for us recently in one important struggle that we had with an employer who was trying to kick us down the gangway. So that's as best I could do in a brief nutshell. but I love the industry. I love the opportunity to speak to you. I love the waterfront and the people on it, the mariners, the longshoremen. When we can put it together, we can create a world. But that's like the stars aligning. And when the stars align, wonderful things can happen. So thank you for your attention, and thank you to Judge Berzon and everyone and my fellow panelists. I'll leave it at that.
Thank you, Don. So our next speaker is Catherine Fisk. Professor Fisk is the Barbara Knocktree Armstrong Distinguished Professor of Law at the University of California at Berkeley Law School. She's written books and articles on both new and historic aspects of labor law and worker organizing. Her forthcoming books are No Neutrals, Lawyers for the 20th Century Labor Movement, which examines the careers of lawyers who represented labor unions, and Speech at Work, like this, which examines the rights of both government and private sector employees and employers to speak at or about work. Catherine teaches labor and employment law, among other things, at Berkeley Law. I believe she's going to talk about the lawyers who represented Harry Bridges and his union, the International Longshore Workers Union. Thank you.
Thank you, Judge Berzon, and thank you so much for including me on this super interesting panel. I have to say my father worked his way through college as a member of Harry Bridges' own local, and then during the war was in the Merchant Marine. On the Pacific Coast and in Hawaii, the history of progressive lawyering in both labor and civil rights is deeply entwined with the history of the ILWU and the waterfront industries. To give you a feeling for this, after explaining a bit about the origins of the labor and civil rights bar in the struggles of the ILWU, I want to talk about 3 legal campaigns, beginning with the effort, one of the many efforts to deport Harry Bridges, and then moving over to Richmond to the effort to desegregate businesses in the area around the shipyards in Richmond, and then all the way up to when the United Farm Workers predecessor union brought the grape strike to Port 50 here in San Francisco. As Captain Marcus said, when the longshoremen in San Francisco struck and the strike spread quickly to all maritime workers in 1934, the employers fought the unions with every legal and illegal weapon they had. On July 5th, 1934, the day that became known as Bloody Thursday, the employers hired strike breakers to drive trucks through the picket lines along the Embarcadero. Using munitions and tear gas supplied by the employers, the San Francisco police gassed and shot picketers, killing 2, one who was on a picket line and one who just finished working a shift at the union soup kitchen. Skillful leadership of that strike vaulted Harry Bridges, an Australian, to the leadership of the union, and he remained there until his death in the 1970s. The employers tried to persuade the Secretary of Labor, Francis Perkins, and President Roosevelt to intervene and shut down the strike with violence. But instead, they handed the matter over to a board convened under a congressional resolution to investigate, mediate, and arbitrate labor disputes. Although Bridges personally opposed arbitration as a way to resolve the dispute, he was outvoted by the membership, and the union was committed to deciding issues through vote of the rank and file. It turned out that the membership was right. After arbitration, the board gave the union most of what it demanded. The union made further gains after another and even bigger strike in 1936 that shut down every West Coast port. It, too, was settled by arbitration, and it established collective bargaining on a coast-wide basis between the ILWU and a multi-employer group then known as the Pacific Maritime Association, or the PMA. The ILWU treated contract negotiation and contract enforcement as an opportunity for rank and file engagement, not as something that could be handed over to the lawyers. Elected committees did everything from drafting contract proposals to negotiating to resolving disputes that arose under the contract. That meant that legal work and internal organizing was an ongoing process and a collaborative process between the lawyers and members. And the member caucuses had little difficulty rejecting legal advice when they thought it detrimental to their organizing goals. The first Pacific Coast union labor firm, which represented the ILWU from its founding until through the 20th century, was formed in 1936 by three offspring of working-class immigrant families, Richard Gladstein, George Anderson, and Aubrey Grossman in San Francisco. The firm was a hub and a training ground for labor lawyers, civil rights lawyers, and civil liberties lawyers for decades. A distinctive aspect of their work was the ongoing defense of Harry Bridges from the government's efforts to deport him between 1938 and the late 1950s. The first case I want to discuss briefly, Wixon versus Bridges, which the Supreme Court decided in 1945, arose from the second deportation case against Bridges, based on a statute making deportable any non-citizen who, quote, affiliated with the Communist Party. It was a statute enacted by Congress for the purpose of deporting Bridges. The process used in the deportation hearing was so unfair that the court set aside the deportation order. Wixon versus Bridges has reemerged today in the cases of Abrego Garcia and students whom the government seeks to deport because of their speech and protest. The memorable lines in the opinion are not from the majority opinion written by Justice Douglas, but are in Justice Murphy's concurring opinion. You might have seen them quoted today or recently. He said, "Seldom, if ever, in the history of this nation has there been such a concentrated and relentless crusade to deport an individual because he dared to exercise the freedom that belongs to him as a human being and that is guaranteed to him by the Constitution." Non-citizens, Justice Murphy continued, quote, "like many of our forebears, were driven from their original homelands by bigoted authorities who denied the existence of freedom and tolerance. It would be a dismal prospect for them to discover that their freedom in the United States is dependent on their conformity to the popular notions of the moment. But they need not make that discovery. The Bill of Rights belongs to them as well as to all citizens." The case has not been overruled. Harry Bridges quipped to his lawyers when they proposed to argue that the latest in the government's 20-year campaign to deport him violated due process, saying, "Hell, I don't deny that I've had due process. I've had all the due process I want." An unintended consequence of the government's relentless campaign against him and the ILWU and other CIO unions was to build an enduring personal and professional network among the lawyers from New York to San Francisco and Los Angeles who represented the CIO unions, the ILWU, through both the National Lawyers Guild, with cooperation of the ACLU. They became very closely affiliated because the campaign against their clients was so closely affiliated. The second case I want to talk to you involving labor and the Bay Area maritime communities grew out of that network of lawyers. In Hughes versus Superior Court, the Supreme Court held in 1950 that civil rights picketing in the Black shipyard community of Richmond was not speech protected by the First Amendment. It came from the same campaign to eliminate race discrimination that Professor Schiller will discuss briefly, but I'm talking about a different part of it. After fair employment practices legislation had died in every California legislative session since 1944 and was rejected by California voters in a 1947 ballot measure, activists had no choice but to work locally to persuade consumers and businesses to end discrimination. Two men, Lewis Richardson and John Hughes, one black and the other white, both civil rights and labor activists, sought to persuade Bay Area stores to hire Black employees. One of their targets was Lucky Stores, an Oakland-based grocery chain that did not employ a single Black person, although they had stores in Black communities, such as in Richmond. After the manager of a Lucky store in a predominantly Black Richmond neighborhood beat and shot a Black consumer whom they suspected of shoplifting, Hughes and Richardson met with the Lucky Company representatives about the incident and also to try and convince the store to hire Black employees. Lucky said that a few Richmond stores would experiment with hiring one clerk each to see whether it angered white customers. Token hiring, which employers confronted with civil rights protests like Hughes and Richardson's, often promised to do, simply perpetuated race discrimination. It didn't end it. And so having gotten nowhere with negotiation, Hughes and Richardson decided to picket with signs saying, "Shoot Jim Crow out of Lucky's," a reference to the shooting, and "Lucky won't hire Negro clerks in proportion to Negro trade. Don't patronize." This was not a radical strategy. Consumer-focused picketing to protest race discrimination by white-owned stores that catered to Black shoppers but refused to hire Black staff had been a successful tactic in the 1930s across the country. Lucky's San Francisco law firm obtained a preliminary injunction against the picketing. The Bay Area NAACP regional secretary wrote to Thurgood Marshall in June 1947 about the injunction and asked for support. Marshall replied that the national NAACP was, quote, vitally interested in this problem and that legal counsel should, quote, take immediate steps to test out precedent to support the right to picket. Marshall opined, given the Supreme Court precedent that such picketing was protected by the Norris LaGuardia Act, which of course targeted to protect labor picketing, but also had been held by the Supreme Court in 1938 to protect civil rights picketing. Marshall said, so this case should be easy to win. So Hughes and Richardson resumed picketing in defiance of the injunction, were arrested, charged with contempt, and sentenced to 2 days in jail and fines. In the litigation challenging this, they were represented by a coalition of labor and civil rights lawyers, most of whom were alumni of the Gladstein firm. They won in the State Court of Appeal, lost in the California Supreme Court, and debated whether to seek cert in the U.S. Supreme Court. Cecil Poole, who was then the San Francisco NAACP's counsel and later became the first African-American judge on this court, recommended against going to the U.S. Supreme Court because he thought it was a bad test case, given that the lower court had characterized the picketing as being advocating a racial quota. It didn't, but the court had bought into the Lucky Stores lawyer's argument that it was. As it turned out, Poole was correct. Hughes and Richardson lost in the Supreme Court in an opinion written by Justice Frankfurter, who discerned disingenuously, I may say, in California law, a policy against a, quote, quota system for hiring. Of course, California law said nothing at the time, nothing at all about that at the time. But nevertheless, Justice Frankfurter relied on the Marinship and Williams cases that Professor Schiller may talk about for this proposition. California didn't actually outlaw race discrimination in hiring until the late 1950s. But what the case was significant for, of course, was holding that civil rights picketing was not protected by the First Amendment, just as labor picketing had lost its First Amendment protection. Later, civil rights picketing regained First Amendment protection, but labor picketing really never has. And so that brings me to the third case that I want to talk about, and then I'll wrap up. It is one at the origins of the United Farm Workers' famous 1966 nationwide boycott of struck grapes. In November and December of 1965, striking farm workers decided to follow truckloads of grapes to the ports of San Francisco, Oakland, and Los Angeles and Long Beach to see if the longshoremen would help them by not loading the struck grapes. 4 strikers posted themselves at Pier 50 in San Francisco. Farm worker union organizer Gilbert Padilla said that as he stood on the Embarcadero with a picket sign saying, "Don't eat grapes," longshoremen walked past, not realizing that they were on strike. Then ILWU local leader Jimmy Herman walked up. When Padilla explained the situation to him, Herman took him back to his office, got down on his hands and knees, and made new picket signs saying, "Farm workers on strike." Herman told Padilla, "You go back there and don't tell nobody who gave you this. You're going to get an injunction as soon as the people find out what's happening. In the meantime, you go ahead and do it. They're going to go after Harry Bridges, who will have no choice but to ask you to leave, because if they get an injunction, they'll get fined. But you do that until that happens." Herman predicted correctly. When Padilla returned to the dock with the new sign, longshoremen stopped work. Padilla then recalled, "That's the first time I felt I was 10 feet tall, man. Everybody walked out. I've never seen anything like it." Truck traffic backed up all along the Embarcadero up to the Bay Bridge, and then the police and the lawyers arrived. And I have a picture, I think, to show of what happened. It seemed that longshoremen were outnumbered on the docks by police, lawyers, college student activists, community activists, and journalists. Among those milling around was Norman Leonard, lawyer for the ILWU, and the lawyer for the grower and the ship owner, Stuart Harrison, of the San Francisco firm Brobeck, Flager, and Harrison. Soon, a process server showed up with an injunction that Harrison had gotten a local judge to issue. A police lieutenant threatened to arrest anyone with a picket sign, but there were more pickets than the police could possibly arrest, so they simply took their signs across the road to join the spectators. Photos like the one I show here show youthful protesters standing outside the pier, holding a picket sign in one hand and a restraining order in another, reading the fine print of the order. In all this excitement, an unusual rift arose in the ranks of management side labor lawyers. The PMA had 30 years of relatively stable bargaining relationships with the ILWU and did not want this labor dispute to shut down the other peers. The lawyer for the PMA called for a meeting of the PMA ILWU Labor Relations Committee because he knew the ILWU would abide by its decision. That did not mollify Mr. Harrison, who wanted his injunction enforced immediately. Harrison swatted away the PMA's concern that the injunction was invalid, saying that by the time the injunction was vacated, the grapes would be shipped and it would be too late. The PMA's lawyer scoffed at this argument, and then Harrison threatened to sue the PMA. Things got even testier across the bay in December when farm workers showed up at the Howard terminal, and longshoremen again refused to load struck grapes. Once again, lawyers, police, photographers, and student and community activists swarmed the area. Picket signs invoked the struggle of the civil rights movement, including the Mississippi Freedom Democratic Party's effort to gain representation at the Democratic Convention in 1964. Harrison was back with another injunction. He got so angry, he attempted to perform a citizen's arrest himself on one of the pickets. And then Norman Leonard later sued Harrison for false arrest. When Harrison threatened to have police arrest longshoremen who refused to load grapes, the ILWU local leader in Oakland told the longshoremen to go home, and the pickets dispersed because it would have been a melee. This longshoremen would have fought back. The action moved from the docks to the law offices, as it often does. ILWU locals were quickly plastered with unfair labor practice charges for engaging in a secondary boycott. The NLRB got a federal injunction against the farm workers for asking the ILWU to support their strike and the ILWU for honoring the request. And 4 suits were filed against the ILWU in state and federal court. Norman Leonard did his best to defend the ILWU in all these proceedings, but he expected to lose, and he did. And both the ILWU and the Farm Workers Union paid damages for the secondary boycott. What the farm workers learned from this imbroglio is that calling for a secondary strike of workers covered by the NLRA was financially ruinous for the unions involved. But a consumer boycott, a tactic they learned from the Student Nonviolent Coordinating Committee volunteers who they had worked with, they learned that they could research the connections. SNCC learned to research the connections between northern businesses and segregated southern institutions and call for a consumer boycott through leafleting. And United Farm Workers learned the same lesson. It attracted attention and heightened awareness of the awful working conditions in the fields and connected the farm workers to a nationwide network of students, activists, and lawyers. And so thus one of the great sort of labor civil rights coalitions of the 1960s was formed in those experiences on the docks. And so now I'm going to turn it over, I guess, after a suitable introduction, to Professor Schiller to tell a different chapter of the story.
Professor Schiller is a professor of law at the University of California College of Law, San Francisco, formerly known as Hastings Law School. Rule Schiller is the Honorable Roger Traynor Chair and Professor of Law at the University of California College of Law, San Francisco. He's a legal historian, among other things. His teaching and scholarship focus on American legal history, administrative law, and labor and employment law. He's written extensively about the legal history of the American administrative state and about the historical development of labor law and employment discrimination law. He's the author of Forging Rivals, Race, Class, Law, and the Collapse of Post-War Liberalism, a prize-winning book about the relationship between labor unions and civil rights organizations in the Bay Area in the years following the Second World War. He's received the American Bar Association Administrative Law Section Scholarship Award and the Rhoda Award for Teaching Excellence. He's a co-editor of the Cambridge University Press's Studies in Labor History book series, and I believe he's going to focus as well on the civil rights struggle of the 1940s among shipbuilding workers, culminating in a landmark California Supreme Court. Thank you, Professor Schiller.
Great, thank you, Judge Berzon, and thank you for Johanna and Georgia for the help of the invitation and the help putting this together. Captain Marcus and Professor Fisk talked about 2 very progressive unions and their relationship to labor and civil rights on the West Coast. I'm going to talk about a much less progressive union and the conflicts it had in connection with World War II that led to, as Judge Berzon said, a landmark civil rights case in the California Supreme Court. And to do this, I have to introduce you to 2 people. And so the first person is a gentleman named Ed Rainbow. And so that, I think, is slide number 2. Let's see if we see him. Neither of these are very well-known figures, so the pictures are not always as clear as you might want. So you'll bear with me. Ed Rainbow was the business agent of Local 6 of the International Brotherhood of Boilermakers, during the 1940s. And you can see him right here. It's an odd picture. This is actually at a scrap metal collection during World War II, where civilians would turn in their sort of excess metal to be turned into, for the purposes of the war. And this is actually really the only picture that we could find of Rainbow. Now, again, he was the business agent of this local, but that's a very modest sounding title, and it really belied his power. Local 6 represented the vast majority of workers building ships at the 5 main Bay Area shipyards during World War II. And at the height of the war, that was over 36,000 jobs. Under the agreement that was signed by the shipbuilders and Local 6, for the duration of the war, the contracts between them were closed shop contracts, meaning that if you wanted to work in the shipyards, you needed authorization from Ed Rainbow. So that's character 1. Character 2, I wish there were a better picture of him. This is Joseph James. Now, Joseph James moved to the Bay Area in the 1930s as a professional singer and was trying to make his career in the arts when World War II broke out. When the war started, he began working at the Marin shipyards, one of the main shipyards, in this case in Sausalito, building tankers and Liberty ships. Now, James, who was a welder, and that was a highly skilled, highly paid job in the shipyards. And he was also a very well-known and well-liked worker at Marin Ship. He sang at all the ship launchings, and he was repeatedly featured in Marin Ship's publicity materials, in trying to sort of bring the idea of World War II as a war about pluralism and a war that was an anti-racist war. If you get maybe the next slide of Joe James, here he's singing. In the previous one, he was actually wearing his welder's goggles. Here he's not. Now, James's race is relevant to our story because at the time that James began working for Marin Ship, and now that's the next one, that's the Marin shipyards. You see them building actually 6 ships there. During the course of the war, Marin Ship was launching a new ship every 2 weeks. The problem that was raised by James and many other Black workers working at the Marin Ship facility was that the Local 6 and the IBB, the Boilermakers Union, like many unions in the United States at the time, was what would be called a Jim Crow union. It only admitted white members. However, because of the demands of wartime production, the shipyards were operating 24 hours a day, and many white workers had been drafted and were fighting in Europe and in the Pacific. There was an enormous demand for workers, and consequently, during the war, shipbuilding companies needed to tap into labor forces that had traditionally been excluded from these highly skilled, high-paying jobs in the shipyards. Probably most famous are women workers, the riveters who were working in these yards. But it was also true of Black men and women who were hired into these high-skilled, high-paid jobs during the course of the war. And this created a problem for Ed Rainbow, right? Because under the closed shop agreements, all the folks working at Marin Ship had to be union members. But the union rules prohibited Black people from becoming members, right? And so as production ramped up in the various shipyards, by 1942, Rainbow was trying to figure out what to do. And he asked the IBB's national office and was told that he should set up a segregated auxiliary local for Black workers. And indeed, this is what the IBB was doing up and down the West Coast and also in East Coast ports. Right? The idea was that for the duration of the war, the IBB would give Black workers auxiliary memberships in the union and then place them in their own separate locals, which would be under the control of what in correspondence they called the real all-white locals. Right? And so Black workers would have no say in the management of their local. They couldn't vote for union officers. They couldn't vote for contracts. They had no control over the arbitration. But it probably won't surprise you to hear that they were, of course, expected to pay dues. When the war was over, the IBB said the plan was to simply disband the auxiliaries and then return the union to its lily white status because all the black workers would lose their jobs. Now, Rainbow, after some foot dragging, and we can talk about why if you want in the Q&A, sets up one of these auxiliaries, and the black workers at Marinship refuse to join. Rainbow then revokes their work authorizations, and in March of 1943, Marinship, by the terms of the closed shop collective bargaining agreement, dismisses all the black workers. Now, in the months leading up to this, when it became clear to workers that the local was going to set up this auxiliary, black workers at Marinship established an organization called the Shipyard Workers Committee Against Segregation and Discrimination. And its president was Joseph James. Now, James was not anti-union, far from it. James was deeply committed to creating a multiracial labor movement. And indeed, the initial protest after the auxiliary was set up was James leading workers to the Local 6 headquarters to try to tender their dues to an exceedingly unhappy Ed Rainbow, who refused to accept them unless they would join the auxiliary. Protest followed at the gates of Marinship and then in the Fillmore district here in San Francisco. Now, at the same time, James started pursuing a parallel legal strategy. He had been corresponding with the NAACP's general counsel, Thurgood Marshall, since the beginning of the year when it became clear that the IBB was planning on setting up this auxiliary local. And Marshall put James in touch with a radical San Francisco lawyer, Herbert Ressner, who was in the exact same circle of attorneys that Professor Fisk was talking about. Ressner was a left-wing, CIO-oriented lawyer who had done some work for the NAACP in San Francisco. And he began working with James a litigation campaign to attempt to abolish this Jim Crow local. Now, the litigation that surrounds the case that Ressner and James brought, which became the Supreme Court, California Supreme Court case, James versus Marinship, has too many twists and turns for me to go into in full detail. Right, injunctions were issued and then dissolved in federal court. The parties moved to state court. There was another injunction issued. There was then an expedited appeal to the California Supreme Court that resulted in a victory for James. And so if we could have the next slide. Here you see this is immediately after they won, and you can see the workers hold what they're holding up there are their authorization cards, right? That there's one, and James is the gentleman with the hat and glasses who doesn't have the authorization card. I guess it's on the left, this person over here. Now, this victory shouldn't hide the fact that when this case was brought in late 1943, an objective assessment of it would have suggested that it was not likely to win. Racial discrimination in private employment was the norm and entirely legal, right? There were no laws. There were no federal laws, no state laws, no interpretation of the constitutions or statutes that prohibited employment discrimination. I mean, indeed, when the parties went first to federal court, the case was dismissed because there was no federal question, because there was no law, right, that prohibited discrimination based on race, right? So in that context, the question is, well, what arguments then did James and Ressner use? And the answer was, now that they ended up in state court, they argued that employment contracts that facilitated race discrimination violated California public policy, right, and thus were not enforceable. Now, in 1943, this was an incredibly difficult argument to make, right? A court under California law at the time could only void a contract as a violation of state public policy if that policy was entirely free from doubt. And in 1943, when you looked at California law and policy, that would be a very hard argument to make. After all, there were not a lot of indications in California state law that racial discrimination was against public policy, right? To the contrary, there was only a single statute that addressed issues of race. It was a civil rights law, but it was designed to only prohibit discrimination in public accommodations and said nothing about employment. I mean, indeed, in 3 different times during the 1930s and 1940s, attempts were made to amend that law, and in each instance, they failed. Additionally, in 1943, that very same year, the California Supreme Court had rejected an argument that racially restrictive covenants violated the public policy exception, right? So in fact, looking at the case law, at the statutes, at the kind of things we teach our students to look at as like public policy that might void a contract, there was not much to be found. Faced with that difficulty, Ressner struck a different strategy. And instead, what he did is he stuck with just much broader, sort of abstract notions of racially egalitarian public policy. He presented the different courts he argued in with a very sort of sanitized version of American history, cherry-picking quotes from Jefferson and Washington, emphasizing Abraham Lincoln's thinking, and of course the Civil War, the 13th, 14th, and 15th Amendments. He pulled many racially egalitarian statements from Franklin Roosevelt, from Roosevelt's opponent, Wendell Willkie, in the election of 1940. He, not surprisingly, found racial egalitarian statements by various labor leaders at the time. You would notice now that there's almost no law here, right? He did refer to an unenforceable executive order prohibiting employment discrimination in the defense industries that the Roosevelt administration had issued. But his main strategy was really to focus on the war. And by focus on the war, what I mean is this. Throughout the litigation, and in every court he argued in, which was the state trial courts, the state appellate courts, the federal trial court, Ressner quoted extensively from Mein Kampf. And his point was simple. An overwhelming national public policy against racism was made most obvious and most compelling by the fact that the country was currently fighting a war against white supremacy and racism, right? That was the tactic that he used, right? And despite the inhospitable doctrinal environment in which he was making these arguments, as you know, he won, right? The court issued a decision saying that the creation of these segregated auxiliaries violated public policy so that the collective bargaining agreement between Marinship and the union couldn't be enforced. And what the court did is it based its decision on the existence of the closed shop, right? This gave a monopoly on labor to the union. It turned unions into quasi-public entities that controlled people's fundamental right to earn a living. And consequently, unions had certain obligations to behave in a non-arbitrary fashion towards their workers. Racial discrimination was obviously arbitrary and against the public policy of the United States and California. And again, as I hope you're getting, that's a great statement, but was definitely wishful thinking on the part of the California Supreme Court at that time. The court cites many of the same references as Ressner does, although not Mein Kampf. And in addition, it's able to take advantage of 2 Supreme Court cases that actually came down in the interim. One is for labor law folks, a very famous case, the Steele versus Louis National Railroad case, which held the NLRA put limits on racial discrimination by unions. And then Smith versus Allwright, a case that prohibited political parties from racially discriminating. I'd note that, again, the California Supreme Court did not actually cite any California cases because there wouldn't have been any to cite at that time, right? But it holds that because the collective bargaining agreement is against public policy, the unions had a choice. They could give up the closed shop, or they could admit members without respect for their race. And the IBB chose the latter of those. It wanted the closed shop, so it admit African-American workers. Now, the final thing I guess I want to say is asking why this case would come out this way in light of the absolute lack of legal basis for it. And I think the answer is the war, right? And 2 things in particular. Nazi racist ideology heightened the salience of race in the minds of these judges. It made obvious the hypocrisy of fighting the Nazis when the U.S. itself was engaging in racial discrimination. It heightened a commitment to racial pluralism among many members of the American judiciary. And the other thing, and then the last slide, and I wish this were a better slide. In fact, gosh, you can barely see that. What this is an editorial cartoon that is actually from the Dispatcher, which was the newspaper of the longshore workers. And what you're seeing here, I guess I'm going to have to explain it to you because it's such a terrible slide. You see a snake. Oh, thank you, Herbert. On which is written racial discrimination, right? And then you see these two hands holding the snake down. And on the sleeves of their jackets, it says California Supreme Court decision, U.S. Supreme Court decision, right? And that's referring to the Marinship case and the Steele case. And the point of this, and again, something that was clearly motivating these judges, was the idea that race division would undermine the war effort. That racial disunity and conflict would disrupt production and undermine morale. Right now, of course, causation is complicated, and I'm happy to talk about it in the Q&A. But let me close with sort of one more basic point, which is Marinship marks a turning point in American law. Right? It marks the moment when this dispute on the waterfront in the Bay Area, marks the moment where for the first time, racial discrimination in employment moved from being something that was only morally repugnant to being something that courts might actually consider to be against the law. Right? So thanks. And again, I'm happy to answer questions about the case.
So thank all of you, and Johanna is going to field any questions that you.
So please just raise your hand if you have a question.
But can I say one thing first?
Yeah, absolutely.
Or two. One is, before we close, I wanted to put a plug in for some parks in Oakland that are at the port in Oakland. If you want to see the port in Oakland in operation, and also some beautiful birds and shoreline. There's the Middle Harbor Shoreline Park and the Portview Park, which are opposite sides of an inlet near the Bay Bridge, and they're really quite beautiful, but also you can see what actually happens at the port.
I'll do a plug too, actually, which is for Richmond also, in the old Kaiser Yards, has an incredible museum, the Rosie the Riveter Museum, which talks about not just how gender worked in that workforce, but also how race did. And you can see right where they were building the ships. It's really another fantastic.
And there's also the Rosie the Riveter Park in Richmond near the old shipbuilding area, which has a lot of interesting history of the home front during the war, and also particularly the racial segregation of that area when so many people came from the South to build the ships.
Indeed. Thank you for both of those. I think we're going to have a bunch of field trips going on soon. I much appreciate it. Well, this has been so fascinating. I have learned so much. I really appreciate it. Thank you to all of our panelists. And now we have some time for questions from the audience. So just raise your hand and I'll ask you to speak up, and then I will repeat the question so that folks who are here, who are participating virtually, can hear. So who has a question? Please just raise your hand and you can direct it to any of the panelists or all of them. Sir.
Are you aware of any plans?
Okay, I'm going to repeat the question, which was to Captain Marcus, whether he was aware of any plans from the U.S. government to start building ships.
Well, there was an executive order, among many others, recently calling for a maritime action plan, MAP, it's called. And the idea is the U.S. trade department is to actually put a fine and a tariff on Chinese-built ships and generate a trust fund to build U.S. ships, to revitalize U.S. shipbuilding. Right now, there's only about 4 or 5 shipyards in the country that can build a large U.S. merchant ship, and there's about half a dozen yards that build naval vessels. But that is in the works. There's also a bill in Congress called the SHIPS Act, which is a Shipbuilding and Infrastructure Act, which would include shipbuilding, maritime training, increasing the size of the U.S. flag fleet, and again, generating a trust fund from the harbor maintenance tax. So there are a number of efforts underway right now to redevelop shipbuilding and increase the size of the merchant marine, all based on fear of China and the fact that China dominates world shipping right now. China controls world trade more than any other nation on the planet.
Thank you. Other questions from the audience? Don't be shy. Sir.
That's a great
I'm going to
question.
repeat the
Oh,
question.
sorry.
When the unions became desegregated, were the jobs themselves segregated or desegregated? Thank you.
Well, so talking about the IBB in particular, what happens is the union is desegregated because of this order, and the jobs are not segregated. The problem is that and this honestly, the folks at the IBB national office, when they're corresponding with Ed Rainbow and are sort of admitting that they've lost, they say, well, this won't be such a big deal anyway because the war is ending and production is going to wind down. And so what happens actually is that as the war ends, the production winds down. They've disbanded the auxiliary locals and they've put people of all races in the regular locals, but the workforce plummets to about 10% of what it was during the war. And of course, because there was systemic discrimination against Black workers, none of them had the seniority to survive this massive cut in jobs. So if you looked at IBB Local 6, and I presume other locals up and down the coast, you would see sort of token integration. And in fact, the high-skilled jobs, were still available to all members of all races, but there were just very few Black people in the union because of seniority rather than because of legal segregation. And honestly, that was something that the Brotherhood folks in St. Louis, which is where they're nationalists, that what they were kind of expecting to happen. So formally, the jobs were open to everyone. Informally, less so.
Sir. Thank you. So thank you for that. I'm not going to continue all of the background, but I think maybe asking for a comment about the evolution of progressive lawyering and perhaps how the purposes and objects have changed over time, and as well as tactics. Thanks.
And for those on Zoom, the question was about Carol Weiss King, who was the dean of and kind of the founder of immigration law as a field. She was a New York lawyer, graduate of Columbia Law School, who wanted to be a civil liberties lawyer. And the way she started her practice was by going out to Ellis Island and talking to people who were having immigration issues and were being turned away for a variety of reasons or deported for political activity. And that's how she sort of created the field of immigration law. And she became connected. I didn't talk about it today in the interest of time, but she became connected to the ILWU lawyers because of the efforts to deport Harry Bridges. But she was also kind of the center node in a network of progressive lawyers in the East Coast, especially. And that's how Norman Leonard actually came to the Gladstein firm, is because he wound up working for Carol Weiss King when he was in law school at Columbia. I think that, and the comment was, the early vision of what it was to be a union lawyer or a radical lawyer in the 30s was to sort of defend people against criminal prosecution so that they could get back out to activism, and that somewhere along the line that changed. One way of thinking about why it changed was because of the enactment of the Taft-Hartley Act of 1947, which made unions liable to suit as an entity for the things that their members did if it was ratified by the leadership. And suddenly it put an enormous amount of money on the line for the union. As illustrated by the farm worker grape strike at the Pier 50, which was small potatoes. But the ILWU was defendant in the first big damages suit against a union arising from a jurisdictional dispute, actually, in Juneau, Alaska, where after the Taft-Hartley Act required that unions purge all communists from their membership, leadership, and they all had to sign affidavits. The ILWU resisted. They considered this a violation of their civil liberties. But unions that were willing to capitulate and purge communists then started raiding the membership of the radical unions. And that's what happened to the ILWU, all basically with the approval of the people at the top of the CIO at the time. I'm looking at Arthur Goldberg. The CIO did not clothe itself in glory in this episode. And so activism became much, much more high stakes for unions, and it became a very, very hard choice about whether you sort of bet the future of the union, because the damages award against the ILWU was at the time more money than the ILWU had in it. Its assets. They ultimately settled it by taking some money that they had won in a wage and hour case in Hawaii and using it to pay off the money went basically from the growers in Hawaii right to the shippers who had sued them, the Juneau Spruce Company. But so all of which is to say the stakes of radical activism really grew after 1947, and lawyers were stuck right smack dab in the middle of trying to figure out whether to, how to advise their clients, and then hope that the clients would make wise choices about how to exercise that power.
These are great questions, everyone. Thank you. I think we have time for one more. If there's another question, please raise your hand. At the back, thank you.
Yeah.
Great
Well,
question. And let me, or you can just repeat the question
No,
yourself.
no, you go ahead.
The question was, how did the Port Chicago disaster, or did the Port Chicago disaster affect the union activism at the time?
Yeah, so there was a whole host. I love this question because it allows me to talk a little bit about something I had to leave out, which was why was it that Ed Rainbow actually delayed a little bit in setting up these auxiliary unions, and so you had a circumstance where Black workers were working jobs in the shipyards, not paying dues, getting as much money as white workers. And that created racial tensions obviously within that workplace. That the whole series, that all the examples of racial tension related to wartime production was one that was hovering in the backs of the minds of all these union leaders, all these government officials. And it's when we were talking about sort of causation around these cases, it's the stuff that judges were thinking about in the context of the war, right? Which is that they saw all these sort of potential tinderboxes, which you're referring to, literally, happening in the context of war production. And it had this effect, I think, of actually advancing, ironically, again, with respect to your question, advancing civil rights by causing judges to be much friendlier to Black litigants than they ever would have been before. Not because, I think many of these Supreme Court justices were genuinely racial egalitarian for their time. But a lot of the things that they were thinking about was, how do we make the country war effort work? And every time there were racialized incidents of violence or disasters or those sorts of things, they saw that as inhibiting the war, right? And that's what Ed Rainbow saw too, right? That was one of the reasons why he didn't act as fast in setting up the locals. And so you had a context in the war of, lots of white people in power sort of walking on pins and needles a little bit with respect to issues of race, something that they hadn't felt the need to do before, right? I think that's one of the things that ended up driving forward a lot of the case law, and not just Marinship, but the Steele case in the Supreme Court and other examples of sort of racially progressive law that was happening at the time.
Well, thank you for the great questions. And alas, we have reached the time where we need to wrap up. So first, I just want to give a warm round of applause for our wonderful panel. Thank you so much. I want to thank everybody who has tuned in from across the circuit. Thank you for joining us. For those of you who are here with us in person, we're going to enjoy a wonderful reception out in the Great Hall. So we hope that you will stay around for that. Thank you, everybody. The Society appreciates your support and participation today.
Hannah?